The following brief was written by Scott Stafne, Esquire, and his AI assistant Todd in the battle to uphold the Constitution. Apparently, as a reward for challenging the courts and the system, the Washington State Bar is trying to sanction him. Reclaiming the constitutional safeguards of judicial power. A historical and legal analysis by Scott Eric Stafne. 1. Introduction. The framers of the United States Constitution were deeply concerned with establishing a judiciary that would be independent, impartial, and restrained by constitutional limits. Drawing from historical precedents, particularly the Act of Settlement of 1701, they incorporated protections in Article 3 designed to cabin judicial power and ensure that judges operated within strict parameters. However, over time, these protections have been eroded, and the judiciary has increasingly departed from these founding principles, leading to significant implications for the administration of justice. This article examines how the original intent of the Constitution's Good Behavior Clause and the right to jury trials have been undermined, the consequences of this erosion, and the urgent need to restore these fundamental safeguards to prevent judicial overreach and tyranny. 2. The historical foundation of judicial independence and the Act of Settlement. The Act of Settlement, 1701, was a landmark statute that enshrined the principles of judicial independence in English law. It established that judges would hold office during good behavior, and that their salaries could not be reduced, ensuring that they were insulated from political pressures. See Act of Settlement. The framers of the U.S. Constitution incorporated these principles into Article 3, recognizing that an independent judiciary was essential for maintaining the rule of law and ensuring impartial justice. The Federalist No. 78, Alexander Hamilton, arguing for the necessity of judicial independence. 3. Judicial precedent and the erosion of constitutional protections. A. Evans v. Gore and United States v. Hatter, affirming and eroding Act of Settlements principles. In Evans v. Gore, 253 U.S. 245, 1920, the Supreme Court held that imposing federal income taxes on judges' salaries violated Article 3's guarantee against salary diminishment. As the framers intended to incorporate the protections established by the Act of Settlement, noting that judicial independence requires protection from salary diminishment. Chief Justice Marshall's statement that judges should have nothing between God and his conscience but the law and the facts of the case reinforced the importance of insulating judges from external pressures. However, in United States v. Hatter, the court reversed Evans, holding that certain non-discriminatory taxes on judicial salaries were permissible, holding that Article 3 protections do not exempt judges from taxes applicable to all citizens. While Hatter altered the application of salary protections, it reaffirmed that Article 3's Good Behavior Clause remains rooted in the principles of judicial independence established by the Act of Settlement. It confirmed that Article 3 incorporates historical protections of judicial independence. B. The selective application of the Good Behavior Clause and judicial overreach. Despite this clear historical and legal foundation, certain district court judges, particularly in the Western District of Washington, have selectively refused to address inquiries related to their authorities and conduct, demonstrating an erosion of the Good Behavior Clause's intended protections. See Bergeron v. Boyd, which raised questions about judicial authority that were not addressed by the court. This selective application reveals a troubling trend where judges are exercising powers beyond the limitations intended by the framers, undermining the principles of judicial independence and impartiality. 4. The founders' intent to cabin judicial power and the role of juries. The founders intended judicial power to be limited by the Good Behavior Clause and by the principle that courts should only resolve genuine judicial inquiries, U.S. Constitution Article 3, S2, Clause 1. Additionally, the Seventh Amendment enshrined the right to a jury trial in cases involving private rights exceeding $20, recognizing that juries serve as a vital check on judicial power, U.S. Constitution Amendment 7. A. The decline of jury trials and the erosion of constitutional protections. Despite this constitutional guarantee, less than 1% of cases today are decided by juries. Factors contributing to this decline include plea bargaining, settlements, and the increasing use of arbitration and administrative processes that bypass jury trials. This trend diminishes the role of juries as a democratic safeguard against judicial overreach. B. Recent case law affirming the right to jury trials in private rights cases. In Jarkisy v. SEC, the Fifth Circuit Court of Appeals ruled that the SEC's administrative proceedings violated the defendant's Seventh Amendment right to a jury trial in matters involving private rights, holding that the Seventh Amendment protects the rights to a jury trial in SEC administrative proceedings. This decision reaffirms that individuals are constitutionally entitled to have factual disputes resolved by a jury if they demand it, especially in cases involving private rights. 5. The dangers of allowing judicial officers to ignore constitutional mandates. Allowing senior judges to ignore the Constitution's mandates is not merely an act of judicial overreach. It represents a fundamental threat to the integrity of the judiciary. See Stern v. Marshall, affirming the importance of judicial accountability to Article 3 standards. When judges disregard the Constitution, they effectively transform from impartial arbiters into unaccountable authorities capable of wielding power beyond the constraints intended by the framers. See Wellness International Network Limited v. Sharif, emphasizing that litigants have the right to Article 3 adjudication unless they consent otherwise. 6. The need to reclaim constitutional protections and hold the judiciary accountable. To restore the integrity of the judiciary, it is imperative to reaffirm the principles established by the Act of Settlement, Article 3, and the Seventh Amendment. Courts must recognize that their authority is inherently limited by the Constitution, and litigants must be empowered to demand that their disputes, especially those involving private rights, must be resolved by an Article 3 judge or a jury as the Constitution guarantees. See Northern Pipeline Construction v. Marathon Pipeline, holding that only Article 3 judges can exercise the full range of judicial power. 7. Conclusion. The founders envisioned a judiciary that would serve as an impartial guardian of the law, constrained by clear constitutional limits to prevent the abuse of power. Over time, these safeguards have weakened, allowing judges to operate beyond their constitutional authority. It is essential to recognize this erosion and take steps to restore the principles that protect judicial independence, impartiality, and the right of litigants to have their cases decided by juries or Article 3 judges. By reaffirming these constitutional protections, we can ensure that the judiciary remains a true pillar of justice, accountable to the rule of law and the rights of the people it serves. Presented by FirstAmendmentFreePress.org.